My understanding is the state is going to be joining us from Miami, correct?
Yes, Your Honor.
Counsel, go ahead.
Good morning. May it please the Court. Joanne Diaz, Assistant Attorney General on behalf of the State of Florida, the appellant in this matter. I would ask, with the Court's indulgence, for 2 minutes for rebuttal.
Yes.
Your Honors, giving a literal interpretation to the term sexual intercourse in this case would lead to an unreasonable and ridiculous conclusion in this matter. The legislative intent of 384.24 subsection 2 was... But
counsel, before we get to that, you know, the first thing this Court is supposed to do when interpreting a statute is to just look at the words that are used. And, you know, the word sexual intercourse is not defined in this statute. And the legislature is presumed to know what it's saying. It says what it means and means what it says. So what is the common understanding of the term sexual intercourse, usually between a man and a woman? And why should we not give what would seem to be the plain meaning of the statute here before jumping to legislative intent?
Well, Your Honor, because the term here is not clear and it's not unambiguous. I'm not asking this Court to broaden the application of this statute. I'm not asking it to modify it or make it more than it is. But I am asking that the Court look at the statute, look at its construction, because to look at it and limit it to the term sexual intercourse the way the appellee would like the Court to look at it would completely nullify the statute. And in looking at that, that's why we need to go into the legislative intent. Look at asking this Court to look at this.
Why do we need to go into the legislative intent when the legislature has defined the phrase sexual intercourse in another criminal statute?
Well, Your Honor, and I'm sorry, I didn't hear you too well, but you're asking me to look as to why the legislator...
The legislature has defined sexual intercourse in another criminal statute, correct? And they define it as between a man and a woman.
In the criminal statutes, that's correct.
And the definition is vaginal penetration by penis.
Correct.
So why should we do something different than what the legislature has already defined?
Because, Your Honor, we're not asking the Court to look at something different. We're asking the Court to look at this particular statute, which falls under Title 29, which is actually public health, and specifically 384, it has to do with sexually transmissible diseases, not criminal statutes.
You're not, Counsel, you're not asking us to look at legislative history. You're asking us simply to look at the terms of a statute, and words have relationship to each other and relationship within the whole, the chapter.
Correct.
You're saying that if you look at the purpose of this statute that is broader than what it may have used to have been thought, perhaps, and beyond that, the limiting interpretive point is that you can't, as universally thought, that you just held that you just cannot interpret a statute in an absurd fashion. And you say, just looking at this statute without looking at anything else, this particular statute in the context of where it sits, but even in the statute without going further, that interpreted it solely as a male and a female is absurd, or at least contrary to the purpose of the statute. Before you get to absurdity, you don't even need to get to absurdity. Isn't that your position?
Yes, Your Honor, correct. Under the doctrine of peri materia, you have to look at this statute where it falls in the whole Florida statutes, which again is public health and then sexually transmissible diseases.
Yeah, but then there is another canon of interpretation. It's called stare decisis, which is often thought to be the primary one, the thing that holds the law together. And the Florida Supreme Court has said that sexual intercourse means actual contact of the sexual organs of two persons and penetration of the body of another. And then 3 years before this statute was adopted, this court in Lanier quoted that provision. And isn't that binding on us? Isn't the Supreme Court decision, aren't the decisions of the Supreme Court binding on this court?
Well, yes, the decisions of the Supreme Court would be binding on this court. And again, in going back to when you're looking at the whole construction and
Well, I understand that. We can look at purpose. We don't need to get into legislative history. We can look at purpose. We can even look at the outer boundaries of it. I shall call whether or not something is absurd. That's certainly a parameter. But if the Florida Supreme Court, even if it were 1926, opined precisely what it is, and if in 1983 in Lanier we readopted, if you will, or used that same language in explaining our decision in that case, why should that not be binding, and let this go on to the Florida Supreme Court perhaps, and let them make a decision, whatever their decision might be?
if it was this court's decision that it should go to the Florida Supreme Court, then that's what would happen.
Counsel, that's not the question. I mean, the Florida Supreme Court decides what they're going to take only if there's a conflict. The question is, if the Florida Supreme Court has spoken on the issue, on the definition of the term sexual intercourse, aren't we bound to follow that?
Yes, Your Honor, but the Supreme Court has also said that you cannot look at a statute and interpret it in such a way that nullifies it.
Well, that's true, but in 1926, the Florida Supreme Court defined it as I've already read it, and so far as I know, there are no statute of limitations on decisions of the Florida Supreme Court. Am I correct?
Correct, Your Honor. But again,
so if that's the case, you concede, correct?
yes, Your Honor. But again, going back to the Supreme Court, they've also said that statutory enactments are to be interpreted to accomplish rather than defeat their purpose, and that's Driver in 1971.
Ms. Diaz, the problem though is, how do we rule against what the Supreme Court has already articulated constitutes sexual intercourse?
Your Honor,
Are you suggesting that we can bypass precedent from the Florida Supreme Court?
no, Your Honor. I'm not asking you to go around the Supreme Court. I'm not saying, in ruling the way we would ask this court to take this back to the trial court, you wouldn't be going against the Supreme Court. Judge Miller's decision was based specifically on LAP, and he said that in his ruling. But LAP was erroneously decided. And this goes back to my original argument that...
Counsel, LAP is us. And whether it was erroneously decided or not, the three of us don't undo that. I mean, we're stuck with LAP just like you're stuck with LAP. It's precedent from this court. The three of us can't change that. I mean, the only way we can work with LAP is to say that LAP was dealing with a different circumstance than existing here.
Well, it was a different circumstance, but when you read LAP, they based their decision saying that it was clear, it was unambiguous. But then they also said that in the absence of statutory definition, it is permissible to look to case law or related statutory provisions that define the term. And that's all.
Counsel, what was the purpose? What was the point in LAP? What was the court addressing it? Was the court addressing this statute in LAP?
Yes. Yes, Your Honor.
The court was addressing this statute in LAP?
In LAP, the second district case from 2001, LAP, out of Manatee County.
I confused you. I was talking about our decision in Lanier, because LAP's from the second, we're not bound by LAP because it's a sister court. But I'm talking about Lanier, where we talked in Lanier about what the definition of sexual intercourse was. We've already been around this block, have we not?
I'm sorry, Your Honor.
Hasn't the Third District Court of Appeal already been around this block on the definition of the term?
If you're talking about Lanier v.
Yes.
State, it was discussed. Lanier was decided in 1983, Your Honor. This statute was not enacted until 1988.
Okay, but what-
1986.
Well, I'm sorry, originally
1986.
1986, and then they amended in 1988.
If we're looking to define things as best we can as of that time, which I think we perhaps are in this type of case, that's 3 years before, and that's pretty close for judicial work, isn't it?
Yes, Your Honor, it is. But again, it goes back to what was the purpose of 384.24 subsection 2? And if we follow the decision as it stands now, you would have a situation.
Well, how do you know, what's the purpose? Well, you have a purpose, and your purpose might be right, and it might seem to be fairly plain. But up in Tallahassee, there were 160 folks that voted on this, if they all voted, and their purpose might have been something different.
Your Honor, I actually think that the purpose was.
I mean, it may be their purpose may be contrary to what the conventional wisdom, let us say, among certain people or among us, let's say, the court perhaps is, and so they're presumed to know what they were talking about.
Your Honor, and they were, and if you look in my brief, I quoted Representative Frankel in discussing the purpose behind this.
Counsel, she just won. She's not a majority. Yeah, she had her opinion, somebody else had their opinion, and perhaps in the, whoever writes all these legislative things that go to whoever they are, these unknown people, they have their opinion. We can't follow one person or one unknown or some unknown people that pass things out up there, can we? I mean, that's contrary to any basic principles. Don't you agree?
I agree, Your Honor, but it helps as a guide. I mean, the purpose behind this was to stop the spread of a deadly disease. This was a time when the country was in crisis as far as this disease. And as it stands right now, the statute, it's telling people how to break the law, how to circumvent it. And if I may, with the court, if you have a woman who's infected and she sleeps with a man on day one and they have the sex, the way it's defined, sexual intercourse here, penis to vagina, the second day that woman sleeps with the same man but has oral sex, in one she's breaking the law, in the second she's not. And she's still possibly infecting the same exact person. That's what's
absurd in your mind.
That's what's absurd about this law. And the whole purpose was to stop this disease, to help stop the spread. And I really believe that when you look at the legislative intent, they talk about HIV carriers, wanting to protect their loved ones, wanting to stop this. I mean, everyone in Florida should be protected. And the way it stands right now, you're allowing people to break the law and possibly infect others. And that's all we're asking this court to do, to
Ms. Diaz, you want to finish your sentence? I've let you go way over your time.
Yes, Your Honor.
We'll still give you a minute for rebuttal. Finish your thought.
I was just going to say that we would just let this go back to the court in Key West so that it can be addressed and let a jury decide this and look at it. But I will speak on rebuttal.
Thank you. We'll hear from the appellee. Counsel, the Third District Court of Appeal is probably the only place in the world where 10 minutes is really 20 or 30.
Thank you, Your Honor. Good morning, Your Honor.
Good morning.
Al, next to you, representing Gary Debaun. The court is well familiar with my argument. It is really based upon the argument that was made in LAPD State, which was the decided about 2 years ago, in June of 2011.
But you know, the problem with that case is the Second District Court of Appeal was looking to other statutes, primarily, I think, for definitions of the word sexual intercourse used in other statutes. And perhaps it could have a different meaning in other statutory schemes, depending on what the purpose of the scheme is. I mean, isn't it possible that the use of the term here, because this statute actually has, the first provision talks about its intent. And the intent of this whole chapter is to prevent transmission of sexually transmittable diseases. So isn't the definition here perhaps a little bit wider? Because, you know, many of these diseases, if not most, can be transmitted, including HIV, in ways other than between male and female, penetration, sex. So why wouldn't the legislature be trying to address the spread of, say, gonorrhea or other diseases by oral sexual acts? Why couldn't we say that it's broad enough as used in this statute to include that?
I think the term sexual intercourse is clear, and it is not to be expanded from what is listed in the statutes that we already have, and also the case law. So that sexual intercourse is between a man and a woman. The statutes have dealt with deviations from that definition by saying that it's deviant sexual intercourse. For instance, if it was between two males, or deviant sexual conduct. They've never really expanded the definition. Weren't
those the statutes that were criminalizing that kind of behaviors for some purpose?
Well, this is criminalizing this kind of behavior. This is a third-degree felony.
For a purpose.
I understand.
And the purpose, I think it's pretty obvious what the purpose is. And so why shouldn't we follow the purpose?
The state is asking you to broaden the definition of sexual intercourse.
No, well, I suppose you can argue it that way, but the state is only asking us to look at a common sense interpretation, if not the obvious, a fairly obvious interpretation. And that does not seem, and they're not, the state attorney said, or the AG said that she was not asking us to go back and look at legislative history or anything like that. She's saying, look at this statute, look at the words, look at the purpose, and on that ground alone, quite apart from other statutes, on that ground alone, and quite apart from the Florida Supreme Court, on that ground alone, this is a reversal.
Your Honor, if this court were to change the definition or add to the definition of sexual intercourse, how far would the court have to go? If we are going to try to stop this,
we just, for this case, we decide cases. We don't decide, we're not a law declaring court. We decide, we're an error correcting court. And we decide this case, and then when the next case comes, somebody else would decide it.
I understand that. Part of the conduct in this case that's been complained of is fellatio. So would fellatio be part of the definition of sexual intercourse?
Well, when you look at the definition in the dictionary, that's one of the things the Florida Supreme Court does, so we are also permitted to just look at the dictionary definition of the word. In the dictionary definition, there are two definitions of sexual intercourse. One is the penetration of the vagina and the penis. That's the first one. And the second one has sexual intercourse as oral and anal. So if you just look in the dictionary, it includes both. Now, I know the Second District Court of Appeal was dealing with digital penetration and oral, but we only, as Judge Shepard says, we only have to deal with what's in front of us. We don't have to think about, well, what is this, the next thing and the next thing. We only have to deal with what the acts are in front of us, whether they would constitute sexual intercourse in the context of this statute.
I believe at the time, Your Honor, that the dictionary definition included anal sex as well as vaginal sex. I don't recall it saying fellatio or cunnilingus or a mouth to sexual organ type sex.
It currently says, it currently does.
It currently says that, but at the time of the legislation, it didn't say that. I believe that the court was clear when they, the legislature was clear when they enacted the statute. And they were trying to spread the stop of HIV through one particular type of conduct. And that conduct is sexual intercourse.
And it was of particular concern to the legislature because over time, the statute was put into two sections, and for the type of conduct involved in this case, the penalty was increased. So it seems to me that the legislature, quite apart from this language, the purpose, as the state says, is to, manage what I think common sense tells us was a difficult situation, if not a crisis, 25 years ago.
But again, the legislature has, in various different statutes, defined sexual conduct. For example, they do in the Chapter 827, which is sexual performance by a child. They talk about deviant sexual intercourse, but they also talk about sexual conduct, and that's an actual defined term, which could be actual sexual intercourse, deviant sexual intercourse, bestiality, sadomasochistic abuse. So clearly the legislature understands how to use phrases and words.
And that is actually part of my point here, that if the legislature wanted to...
They could have said sexual conduct.
They could have said deviant sexual intercourse.
Or sexual activities.
Exactly, sexual activities or sexual conduct, anything that deviates
Well, sexual activity, as we know from Lanier, or could include fondling, which is not necessarily a manner in which an STD is transmitted from one person to another. I think fondling was criminalized in Lanier, was the statute in Lanier. Well, that's inappropriate conduct of a sort of a sexual nature. I think the legislature perhaps was trying not to box itself in this statute, because in the time frame that this was included, it didn't say HIV at the time, as you know, in 1986, but it had what people believed was, at the time, the vector for this disease. And that at that time was believed to be just between males, men and men. So what would be the purpose in having a statute saying you have to disclose this if it's primarily, at the time, was thought to be transmitted not between a man and woman, but between two men?
I think the legislature could have delineated in this statute deviant sexual behavior, which is how they refer to anything that deviates from sex between a man and a woman. So traditionally, in our state, sexual intercourse has always been between a man and a woman. Anytime that
but things, counsel, things do change. So even going back to the way that the Florida Supreme Court fairly clearly said what sexual intercourse is in 1926, words have a meaning within context. They're colored by their context. Words, there's some famous author or judge who has said words are like chameleons. They're colored by their context. And so I don't know that we should be so concerned about what the case law says or even the statutes. If you just look at this, things change. 1926 is one period. Now we're here, for whatever, better or worse, so to speak. And so, I don't know when those other definitions came in, deviant intercourse, deviant sexual intercourse, and so on, but it seems to me we look at these words as they're colored by the statute, if not the times, but the statute for sure. Don't you agree?
Well, I believe the statute is clear, Your Honor. Mm-hmm. And I believe that the words are clear. And therefore.
But you only get there by looking at other statutes and maybe the Florida Supreme Court.
Well, and that's what I've done. I've looked at other statutes and the way sexual intercourse has been defined, and I've also looked at how the legislature has looked at anything that deviates from sexual intercourse. And certainly those words could have been used in the statute. I believe that the intent of the statute is clear and that the words are clear, and therefore we shouldn't really get into statutory interpretation or construction.
Or the legislature also, even when it talks about sexual battery is specifically defined as oral, anal, vaginal penetration. I mean, they have a whole list of what constitutes certain sexual activities. So again, you know, it's a dangerous ground where we're trying to surmise what the legislature means when the legislature defines certain terms as it chooses.
That's correct, Your Honor. I believe that in this particular case, well, let me also mention that LAP was decided 2 years ago. Of course, the legislature has had the opportunity, and that's been the law of the state of Florida for these 2 years. The legislature has had the opportunity to amend the statute. Nothing has been done in that regard. For the past 2 years, it's just been sex between a man and a woman that was criminalized and based upon LAP. The legislature has not decided to do that. They have not moved to amend the statute to clarify it in any way or to give it any other purpose. So I believe that we have to stick with the language here, and the language is sexual intercourse. And
Counsel, we've let you exceed your time too, so would you bring it to a close?
Yes, Your Honor. I want to thank you for your time. This is the first time I've ever argued before in a public court. It has been a great experience, and I ask you to uphold the trial court's ruling with dismissal of the information.
Thank you, Counsel.
Thank you, Counsel.
We'll now hear from the state for 1 minute.
Very briefly, Your Honor. This particular statute is not prohibiting sexual intercourse or the act of sex. What it's prohibiting is having an infected person possibly infecting their partner.
It's prohibiting someone who knows, because they have to knows that they have a sexually transmitted disease from having sexual intercourse, because that's the actual defined term. It's not defined, but that's the actual term that's used in the statute. It's sexual intercourse. You must engage in sexual intercourse knowing that you have a sexually transmitted disease that you can pass to another person. And the issue I have, and you really have not addressed it, I think, satisfactorily, which is how do we deal with the Supreme Court's case that defines sexual intercourse as meaning actual contact with the sexual organs of a man and a woman and an actual penetration into the body of the latter. And that's clear language from the Florida Supreme Court that this court has cited in Lanier. So how do we get around that? We're panel of 3. We're not en banc. So how can we distinguish that?
Your Honor, when you're citing to Lanier, you're citing the 1985 Supreme Court case, correct?
No, I'm citing to the 1926 case from Williams v. State from the Florida Supreme Court that defines sexual intercourse means actual contact of the sexual organs of a man and a woman and an actual penetration into the body of the latter. So how do we ignore that Supreme Court case?
You don't need to ignore it, Your Honor, but you can acknowledge that if you're looking at 1926,
All cases from...
I'm
all
sorry,
cases-
Your Honors, we got cut out for a minute.
Okay,
You were explaining what happened in 1926 in the Florida Supreme Court. Go ahead and finish your thought.
Yes, Your Honors. Just that this, first of all, this statute did not exist in 1926. Second of all, AIDS and HIV were not known in 1926.
But there were sexually transmitted diseases in 1926, such as gonorrhea and syphilis. So again, how do we distinguish the Florida Supreme Court's case that actually defines sexual intercourse?
I would quote Lanier, where it says that although the Supreme Court is not bound by statements of legislative intent, uttered subsequent to either enactment of a statute or alleged violation, the court will show great deference to such statements. You can show great deference, but you can still acknowledge that things have changed, and the term sexual intercourse is now understood to mean more than just the traditional male to female, penis to vagina intercourse. And the only other thing I would say, Your Honor, in addressing the appellant was that...
Briefly, counsel. 1 minute has stretched into 5.
I'm sorry, Your Honors. Again, the term sexual intercourse, using all the case law and everything we've seen, obviously it's not clear if there is this dispute that's going on. We would just ask this court to reverse Judge Miller's ruling and let this go back to the trial court in Key West.
Thank you, counsel.
Thank you.
Thank you both.